Okay. Call us to order. We'll start off with the Pledge of Allegiance. Those who would rise and join.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good. So I'm going to do my introduction, and then I'll get you to stand back up. For those who haven't been to a code enforcement proceeding before, my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the City of St. Cloud. My role is to be an independent finder of fact. I am retained for that purpose. I do not represent the city. I am an attorney, but I do not represent the city. The way we will proceed today is the city will present its case. When they have presented all the evidence they intend to, the respondent will be given an opportunity to ask any questions of the code enforcement officer you may have, or to present any testimony and evidence that you want me to receive. When I received all the evidence and testimony, I will enter a verbal ruling today. That will be followed in the mail by a written order. With that, if anybody who's going to testify would stand so I can see who's being sworn, and raise your right hand. Do you all swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth? Thank you.
Case number 2021-2551, Victor Alberto Baez Fibo, owner, location of violation 815 Illinois Avenue, St. Cloud, Florida.
Good afternoon, Your Honor. Jack Morgeson for the city. I'm starting a little bit unusually this afternoon because we would like to enter into, I believe what we have is an agreement in concept with the respondent on this particular matter. Counsel, Ms. Aldreche, is here in the audience. She may want to speak with you after I've concluded. But essentially, a little bit of history of the case, without going on ad nauseum, is that this property about a year ago was before the Board of Adjustment, and a variance was bestowed upon the respondent with regard to a setback issue. That led to some confusion, we believe, and what's been confirmed by counsel, some confusion with regard to the violations that were detected by code enforcement with regard to failure to obtain permits for improvements and such, and also a zoning violation in terms of the use of property that are issued today. We've communicated extensively with respondent and counsel and have agreed that there are violations that exist because now the respondent understands that the variance as to the setback didn't have the ability to grant a change in the zoning and or deal with the permit. And so the city would be willing to agree to a compliance date set of on or before July 31st of this year, which is essentially a little bit more than 90 days from today, and a recovery of the costs incurred, which I have listed as $338.66 within 60 days of your magistrate's order. I've confirmed those dates and amounts and times with Ms. Aldreche. So that is where we are as we stand before you today, and she is here to comment if I've misspoken.
Okay.
Morgeson.
Okay. As Mr. Morgan has stated, we have stipulated for a 90-day extension. There was some confusion between the variance, and we now understand that in order to change the zoning, we have to submit a separate permit.
Just 1 second. For the record, if you would state your name, I know Jack said it.
Oh, yes, I'm sorry. Jennifer Altreche for respondent Victor Fibo, Baez Fibo.
Go ahead.
Okay, so now we understand the process. We will be submitting a conditional use zoning application to comply. I believe there's 2 structures that right now that are not in compliance. One of the structures will be put in compliance probably sooner than the 90 days because we're going to be stripping it, specifically the garage, and the application we'll be submitting for the zoning will be for the in-law suite.
If I could, I don't mean to interrupt this, but don't want to belabor the point. In terms of how the respondent achieves the compliance, there may need some work to be done between the respondent and the building department in the city in terms of how, because there may be obstacles that at the moment are not, that the respondent doesn't appreciate, that their current plan may have to be deviated from.
Talking about the use?
Correct. And so we have concerns about how that can be remedied, but we've discussed, council has discussed that in the event that compliance doesn't appear to be likely to be achieved by the July 31st timeframe, we can stipulate to an extension of the compliance deadline, either by appearing before you to get that extension, or maybe a stipulation that you would consider, as long as we present that to you before the compliance.
If the parties are in agreement on a continuance, I'm going to grant it. So it's, if you guys are stipulating to it, you can put it on the agenda, I'll approve it. But if the parties have stipulated,
And to be clear, though,
don't have to haul them
the
in
agreement
either.
that we have here today is that the violations do exist, so we'd like findings of noncompliance, but that the compliance date at this time be set at on or before July 31st of this year. And then again, the city will work diligently with respondent as best as possible to address any compliance issues that can be achieved.
so the violations that I have for this case are allowing construction activity without proper permits for the two structures. Is that correct?
That's correct, yes.
Who's gonna,
Officer
who's
Miller,
the
sir.
code enforcement officer? I'll let,
Good afternoon.
since you know the case. Go ahead,
Alex
Citro.
Miller. Yes, sir. Alex Miller, Code Enforcement Officer for the City of St. Cloud. That is correct.
So building permits
Yes, sir.
for the two new structures, that's the only building permit issue is for the new structures,
Yes, sir.
correct? Okay. And the use of one of those structures as an in-law suite, is that the zoning violation?
Confirm, as well as the detached garage, because both units were turned into livable space.
Okay, so we have two non-attached structures that are livable space,
Correct.
and that's the zoning violation?
Yes, sir. And prohibited uses and structures.
Any other violations?
No, sir.
Okay. Counsel? So you've heard the violations. Are those the violations that you are stipulating that those violations do exist on the property?
Yes.
Okay. Okay. Based on the stipulation of the parties, I find in favor of the city, find the respondent is in violation for construction activity without building permits, also zoning violation related to the use of the two structures, the two detached structures. Order compliance be met by 7/31/2022. I'm going to go ahead and put language in the order that says what I said out loud, which is that if you agree to an extension of that, just submit something and put it on the agenda, and if there's nothing to discuss, I will enter that order at the next at that hearing. Also order the respondent to pay the administrative costs incurred by the city in the action in the amount of $338.66, which amount will be due 60 days from the date of my written order. Anything else either party needs from me?
No, sir, I'm good. Thank you.
Thank you.
Case number 2022-192, DSB Real Estate Investment LLC, Susan B. Alvarez, Catherine B. Edmondson, owners, location of violation, 1320 Jersey Avenue, St. Cloud, Florida.
Good afternoon. Alex Miller, Code Enforcement Officer for the City of St. Cloud. I'm presenting this case for the property located at 1320 Jersey Avenue. At this time, I would like to enter into evidence the following items: copy of the notice of violation, copy of the notice of violation sent by certified mail, copy of the notice of violation sent by regular mail posted at the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted at the property and City Hall, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, copy of the sections in violation, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $268.65, and the respondent is not here. On January 19, 2022, during routine patrol, I observed work being performed at this location. I verified that there was no permit on record. I made contact with the handyman working at this location and requested that he stops working until a permit is obtained. The handyman called the owner, who stated that there is a permit on record. I explained once again that there's no application on record in our system and gave them 7 working days to correct the violation. The handyman stated that he will be gathering his tools and leave after cleaning. 4 photos were taken. On February 1st, a reinspection was performed, and now I observed the grass and weeds were high, no permit and no business tax receipt license to rent were obtained, and the property was still in violation. On February 2nd, 2022, a notice of violation was sent by regular mail to the owner and agent to correct the violations within 7 working days. On February 17, a reinspection was performed, and the handyman was at the property doing some cleaning and provided me with the owner's phone number. I made contact with the owner to make sure she was aware of the violations, but she was not receptive to the information I provided. A notice of violation was sent by certified mail to the owner and agent to correct the violation within 7 working days. 4 photos were taken.
What work was being done?
They removed the ramp that wrapped all the way around to the back of the parking lot. So you see the back, it wrapped from the front all the way to the back parking lot. I can't show it. So that's the ramp, but it goes all the way to the back to the parking lot.
So was it a deck?
A ramp deck for wheelchair accessible.
Handicap access?
Yes, sir. On March 7, a reinspection was performed and verified that the property was still in violation. A notice of violation was sent by regular mail to the owner and agent to correct the violation within 7 working days. Posted the property in City Hall and created an affidavit of posting, and 7 photos were taken. Sorry, I don't know where I am. Okay. On March 28, a reinspection was performed and verified that the property was still in violation, and 5 photos were taken.
Had the vegetation been trimmed at all in this period in between your inspections?
Yes, sir. On the future inspection,
Prior
no,
to
after.
this inspection?
No, that was after I
March
posted
28.
the property with a statement of violation and notice of hearing. On March 29, a statement of violation and notice of hearing was sent by certified mail to the owner and agent, posted the property in City Hall, and created an affidavit of posting, and 1 photo was taken. On April 15, a reinspection was performed and verified that the grass and weeds violation was corrected, but no permit or a business tax receipt, land, or license had been issued, and the property was still in violation.
Is the property currently being rented?
A tenant just moved in, and yes, sir. I have only 4 photos of that. Deck's still not finished. And I did a reinspection today, and there's still no permit or land or
Have you had any
license.
further communication with the respondent?
No, sir. The only communication we received is the owner had contacted the mayor and require information. We send the information back about the case, and I know that our building director tried to contact the owner, but never returned the call. It is the city's recommendation that the respondent be found in violation of allowing the grass and weeds to be over the height of 8 inches, allowing construction of repairs and alterations to this property prior to obtaining a permit, and not obtaining a business tax receipt, land, or license by the time specified. The city will recommend that the respondent be given until May 2nd, 2022, to obtain a permit or a fine in the amount of $250 be assessed until compliance is met. The city will also request that the cost incurred in bringing this case before the magistrate in the amount of $268.65 to be paid within 7 days of the written order by the special magistrate.
They still do not have business tax receipt,
No, sir.
and no application for permits have been filed.
No, sir, as of today.
And the request is that they be ordered to obtain permits by May 2nd, correct?
Yes, sir.
Not apply for.
No, obtain.
And is that enough time for them to obtain?
I would say yes.
Can you go back? There was a photo that showed the opening where the deck had been cut off, it looks like, or the ramp had been cut off.
Yes, sir.
Is that the current condition?
Yes, sir.
Is there, are there any areas of that decking that's exposed where somebody could step off and fall?
No, sir, that's the only condition there is. I mean, they're currently using the front, which has stairs. I don't know if you,
A normal stairway up to the deck. It was those type of things that I was concerned about as there being a fall hazard.
yeah, but they have placed those two pieces of wood across. So, and I know I spoke with the tenant when I went to post the property, and he said that he tried to contact the owner, and the same condition. It's been like that since I've been trying to get a hold of the owner.
Do you know how those 2x4s are secured?
No, sir.
And no respondent is here today on this case? Nobody step up. I will find in favor of the city based on the evidence testimony. Find that the respondent was in violation for allowing the grass and weeds to grow over a height of 8 inches. Find that respondent did not cure that violation within the time allowed by the city, but they did cure it prior to today's hearing, so I will enter a finding of fact only as to that. As to the building permit, and business tax receipt, find in favor of the city. Find the respondent is in violation. Order respondent to cure both of those violations by May 2nd, 2022. And I will award or will enter the order to say that if they don't comply by that compliance date, a fine of $250 per day to be assessed until they do come into compliance. And my basis for the $250 fine on this is my concerns about the safety.
Yes, sir.
And that's an unsafe condition there that needs to be remedied quickly.
Yes, sir.
Also, order the respondent to pay the administrative costs incurred by the city in the amount of $268.65, which amount shall be due within 7 days of the date of my written order.
Thank you.
Thank you.
Case number 2022-210, South Florida Barbecue of St. Cloud, Florida. St. Cloud Inc., owner, location of violation, 4475 13th Street, St. Cloud, Florida.
Good afternoon, Melissa Howes, Code Enforcement Officer for the City of St. Cloud. At this time, I would like to enter into evidence the following items: a copy of the notice of violation sent by regular mail, a copy of the notice of violation sent by certified mail, a copy of the notice of violation sent by regular mail posted on the property and City Hall, a copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall with the corrected date for the magistrate meeting, copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code sections in violation of, copy of the deed to the property, and a copy of the costs incurred if the magistrate finds the respondent in violation in the amount of $254.16, and the respondent is not here. On February 4th, 2022, during routine patrol, I observed high grass and weeds in various areas at this location. On February the 8th, I sent out a notice of violation by regular mail to the owner of record and registered agent, giving them 7 working days to correct the violation. On February 17th, a reinspection was performed and the grass and weeds had not been cut. I also noticed during my inspection that there was a lot of loose trash and dead branches piled up all over the property. The property is vacant. It's commercial property and has been vacant for quite some time, but the property needed to be maintained in a clean sanitary condition. I sent out a notice of violation by certified mail, adding the violation of not maintaining the exterior property areas. On March the 2nd, I went back to the property and it was not in compliance. I took 16 photographs.
Go back one. What am I looking at?
Overgrown landscaping, chairs.
What's going on with that palm?
What's wrong with it?
What's going on with that palm?
That's their drive-through window, or used to be the drive-through window. I mean,
Is it growing out of the building?
well, I think it was just planted next to the building, and it's
It's
just,
grown into the building?
yeah, I don't know.
Okay.
It's out of control. And I lost my count, so we're gonna have to just go with the,
You're on 3-2 still.
okay.
Go back again. What are you showing me in this picture?
I'm showing you the landscaping where there's dead branches and trash that's just accumulating.
Okay.
There's some better photos when we get further into it. That's the landscaping out by the highway. On March 4th, I sent out a notice of violation by regular mail, posted the property in City Hall, did an affidavit of posting, and took the photograph of the posting. On March 17th, a reinspection was performed and the property was still in violation. I took 8 photos.
Had they done work between the 2 inspections?
It looked like somebody may have come in and tried to mow the bigger areas, but none of the smaller areas. On March 25th, I sent out a statement of violation and notice of hearing by certified mail. I posted the property in City Hall. I did an affidavit of posting and took 1 photo. On March 29th, I realized I'd put the wrong date for the magistrate on the statement of violation and notice of hearing, so I created a new statement of violation and notice of hearing with the corrected date of the meeting. I sent it to the owner of record and registered agent by certified mail, posted the property in City Hall, did an affidavit of posting, and took another photo of the posting. On April 14th, I was in the area and I noticed that some of the grass and weeds, this is when I noticed it had been cut in some of the areas, but the exterior property areas were getting worse. There were still areas with high weeds, and I took 22 photographs. So like the areas that you see from the highway didn't look quite as bad, but like these are side views and rear views of the property, so you can see the highways out front. So,
You can go back to the last one.
yeah,
On the left-hand side of the frame, what's the black?
that's wood, some kind of wood. We're starting to attract the homeless people there. You're gonna see other photographs that shows bedding and different stuff. That's between the gas station and Sonny's, and
Is that on this property?
yeah, it's on this property. You can see the gas station. And then this is in the rear of the property where the dumpster used to be. There is no dumpster. The fencing's been pretty much taken down except for the post, but there's just trash everywhere. That's where the dumpster was again. This is out front, looking from the rear towards the highway. And then there's somebody's bedding where they're sleeping. The trash is starting to accumulate. People are dumping. And same with the landscaping areas. When they come in and mow, I think they just throw the branches in there. I've got somebody sleeping right there by the door. And it's just right there. See, he's got a piece of carpet there, and the police are trying to do as much as they can. We're getting a lot more homeless in the area. They're trying to do as much as they can. I don't even know if we have a trespass affidavit on file. I can check on that.
Have you had any communication from the property owner?
No, and typically every time we've ever cited this property, there's a certain gentleman that would always call us that said he'd go out and take care of it, and we've not heard anything. I don't have any contact information for the owner at all. It's an individual owner. It's not like they were separated when I looked at the deeds from like a chain. He was separated from the chain and individually owned. On April 18th, a reinspection was performed for today's magistrate meeting, and nothing had changed from April 14th. Inspection, trash was still everywhere, grass was high, so I didn't take any more photos. It is the city's recommendation that the respondent be found in violation of having high grass and weeds and not maintaining the exterior property areas in a clean sanitary condition by the time specified. The city would like to give the respondent until May 2nd, 2022 to correct the violations or pay a fine in the amount of $100 a day until compliance is met. The city would also request the costs incurred in bringing this case before the magistrate in the amount of $254.16 be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
And nobody's here on this case? Based on testimony and evidence received, I'll find in favor of the city, find that the respondent is in violation for having high grass and weeds above a height of 8 inches, and also in violation for failing to maintain the exterior of the property in a clean and sanitary manner. Give the respondent until May 2nd, 2022 to correct the violation. If not brought into compliance by that time, a fine in the amount of $100 per day shall run until the respondent complies with my order. Also order the respondent to pay the administrative costs incurred by the city in the amount of $254.16, which amount will be due within 7 days of the date of that written order.
Thank you, sir.
Unfinished business. Consolidation of cases 2021-991, 993, 994, and 995. Canopy Walk, HOA, Inc., owner, location of violation, Canopy Walk, tracks N, O, P, and Q, landscape, buffer, St. Cloud, Florida.
Jack Morrison for the city, and Attorney Rachel Pringle is also here for Canopy Walk this afternoon, Your Honor. This is on the city's motion for an order imposing fine and creating lien on the property. This stems from the case, you may recall this from back in August when you heard the case. The affidavits of noncompliance and compliance, not partial, full compliance, are attached as exhibits. The calculation of the fine that were to run pursuant to the order, $100 a day. My Minneapolis Public School math, I was off by $100. So it's 118 days. $100 per day would be an $11,800 fine accruing based on that time frame. The costs, I understand, have been paid, and so the city is seeking for the imposition of the fine. I know Ms. Pringle wants to be heard on this. This goes back to a failure to comply with the site plan, and I'm sure you recall it. So, unless there's, and Officer House is here for any questions with regard to the property. So.
Good afternoon. Rachel Pringle with Arias Bossinger. We represent the association Canopy Walk. As Mr. Morganson mentioned, we were here back in August addressing the issues of several community area property-owned, association-owned, pieces of property that did not have the proper drip irrigation and viburnum bush landscape installation as identified on the site plan submitted by D.R. Horton. There was some discussion with the city prior to that who would be responsible. We determined the association was because they were the current owners of the tracts in question. At that time, with your understanding of HOA law and the way the governing documents in Chapter 720 determine how an association is able to proceed with regards to common area association-owned parcels, it was our understanding that as long as the association was making a diligent effort to come into compliance, failure to not comply by the November 2nd date would not result in immediate accrual of fines. When the order was issued and we received it, I was concerned about the language. We addressed this with Mr. Morganson. I spoke to Ms. House as well, and then spoke to you. No disrespect in attempting any ex parte communication. we believed that, after your response, this was resolved, and that an interim hearing to assess fines would be held after November 2nd and failure to come into compliance. All of that understood. We are here to show that the association was diligently attempting to come into compliance. At our hearing, we had 2 estimates, one for the installation of the viburnum, one for repair of a control panel that had to occur prior to any assessment or repair of the drip irrigation.
Irrigation control panel?
Yes.
So you couldn't put in landscaping without the irrigation working right, or the
couldn't put the
landscaping would
drip
die?
line without the panel. That work was being planned. Unfortunately, following our hearing on September 18th, lightning struck the panel. The panel now had to be reassessed, the cost re-estimated. We got that estimation on September 22nd, and then on November 4th and November 16th, both of those things were fixed. In the meantime, we were attempting to reach D.R. Horton. That did not come to fruition, but the association was pulling any estimates they needed for competitive bids under the documents in 720. On October 21st, the association held their budget meeting, at which they discussed moving forward with receiving invoices and improving those invoices. We also discussed the possibility of a special assessment in the event that the cost of repair exceeded the requirement necessary to meet the membership approval threshold under the governing documents. Estimates for the drip line installation and viburnum installation were complete by November 16th. The association put together those invoice costs, determined that a special assessment could be approved at a board meeting. Notice was sent out November 29th. The special assessment hearing was held on December 13th, and special assessment was approved by the board. Given that it was the holidays, the board decided to give the membership until February to pay that special assessment amount. Following that, invoices and installation of the drip line, valve locates installations, fixture repair of a broken water main, I believe, that's located on an individual's rear lot. It's placed by the developer but owned by the association on private property. That had to be fixed. It was fixed on the 21st.
February?
Yes. Following that, the viburnum was installed. We contacted Ms. Howes on the 28th. She inspected, found the properties to be in compliance.
So when did all the work actually start?
The work started, I believe, on the 22nd,
Of February?
of September 22nd,
Oh.
when we had the lightning strike. They came out to look at that control panel.
When did they actually start putting in the infrastructure, putting in the landscaping?
The beginning of February, after the special assessment was due and owing by all of the membership.
Okay. So what was the purpose of that delay?
The association had no funds to meet invoice requirements.
So there was not money in the bank to pay the bills if they had gone forward with the work?
Correct. They did as much work as they could, which is why that control panel got fixed and some of the additional work necessary to install the drip line was done. But other than up and above that, for the plants and the actual drip line installation, the association had to have the money from the special assessment.
So if I'm understanding the position correctly, it was because the homeowners association had to work through homeowners association issues before they could contract for the work, or before they could actually commence the work. That was the main delay that was going on.
Correct.
Were there any materials delays or anything like that?
There did the lightning strike and the pipe break. I don't know whether or not there were materials delays. I assume there were delays in scheduling due to holidays and the amount of work being done by contractors in this area. I do not necessarily have any written communication between the association and the contractors regarding that.
When did the association begin working through the how are we going to pay for it part?
Well, they began getting their invoices in July. Then this act of God happened, had to reassess that invoice.
How much did that add to the cost of the project?
Let me see, sorry. I have them down. If you would like a copy, I have one. So this is for the core hybrid and the solar panels was 1,100. I don't have a copy of the other estimate, but the invoice ended up being, it looks like an additional $70 just for checking the system afterwards. It ended up being an additional $969 if you'd like a copy.
That
It's
was the cost of the light, that was the added cost because of the lightning.
the lightning,
strike.
yes, that's what it looks like from this invoice.
And I was exploring that. When did the association actually start figuring out, and they may not have had a board meeting yet, but when did they start working towards how are we going to pay for this? If that's the delay, I'm looking for good faith. So I'm trying to give you an opportunity to show me where there was good faith in that delay.
By the end of September, beginning of October, we were discussing options and reviewing the governing documents to determine how that could happen. We did not have a completed estimate of cost until November 16th.
And you needed the completed estimates before you could do anything with a special assessment because you needed to know what the special assessment
Whether we
was
needed a
for.
membership vote or it could be a board vote.
And so then you're into the holidays, and the special assessment is approved early February? Do I have
The special
timing right?
assessment was approved in December. The membership were given until the
60
beginning of
days to pay.
February to pay.
And so money, association, at that point, was the association was it waiting for the due date, or was it simply waiting for there to be money in the bank so it could cover bills once bills started coming in?
I think as evidenced by the invoices and the timing the work was done, they were waiting for the due date. Prior to that, they were conducting that work that they had sufficient funds to do, namely the solar panel and the control panel necessary to operate the drip line necessary to keep the plants alive.
How many members are in this association?
There are only 3 members in the association? 193? 193.
Anything else you want to tell me right now?
I'm happy to answer whatever questions.
I don't have any more for you right now. I was going to ask the city to come back up, and I asked them some questions, but I may ask you back up. If he says anything that you'd like to respond to, you'll be given that opportunity.
I would like to state it probably would have been behooving on me to follow up with the city after we did not hear back anything in November. I do apologize for that. I hope that you do not take that
None
as.
taken, absolutely, no, not at all.
Thank you.
So you've heard
Yes, sir.
their history, and $11,800 is a lot for a small association.
Understood, of course.
And I think the chain of events that they are describing, having done association work, is completely reasonable to me. And if they don't have, as we heard in the first hearing, this was not an issue, a problem they were expecting to have. So I don't think this is something where I would sit here and say, well, why didn't you have reserves? Because this wasn't a reserve type issue. So I am persuaded a fair amount by the chain of events, and I am going to move off of that number, but I would like to give you an opportunity to have your say,
Sure.
knowing what I'm thinking.
Well, I appreciate that, Your Honor, and in talking with Officer House, the city, as you well know, and as I know Attorney Pringle knows, is looking for compliance, not looking to be punitive in these proceedings. Obviously, there's been some work that's been, committed to by the staff. We certainly understand that the magistrate was going to consider the number that had accumulated technically to be fairly large, and I've done work with associations myself, so I'm well aware of the intricacies of managing through those types of issues. I don't want to impact the magistrate's independent consideration of an appropriate amount, given the circumstances, but the city is certainly prepared to accept, a reasonable amount that the magistrate feels would be more than appropriate to address all parties and take everything into consideration, if that's vague enough for you.
I give that kind of answer all the time. Okay, Ms. Pringle, if you'd come back up, I did, so with that, all that said, so you also heard what I have to say. Here's where I'm going to challenge you a little bit on this. Not so much to challenge you, but it's what I'm having to sit with up here.
Understood.
There are lots of times when there are people that come to these hearings that, they have a big problem. And it's a big problem they weren't expecting to have, but they have to fix it. And I've sat here and listened to individuals tell me, I don't have the money to do this. And I have to tell them, I'm sorry. My role here is to say, is the code being complied with? I see that it's not. I will work with you on time, and I know that that's part of where we are on this one, because that did get missed by all of us. That's why you don't have to take any more blame than anybody else here. But it's that waiting for there to be money in the bank before it starts, and I know there were a lot of hoops to jump through, so I'm not, unless you have a magical argument that you haven't given yet, I'm not there to take it to zero. But I am going to take it substantially down. I'm going to think about that a little bit while I keep talking, but I wanted to tell you where my head is at on this side of it, to see if you want to try to make that magical argument.
I don't know that there is a magical argument per se. I think that the association took the steps necessary at the very beginning to try and mitigate these costs. It ended up being $14,000.
Was that the total cost of the project?
Total cost of the special assessment. Plus
So the
money.
project was even more than that?
Yes, plus the
Because-
additional funds that were expended to do the preliminary stuff that they didn't need approval to do. I think the association tried to get in contact with D.R. Horton. We received no response. When we realized that that was absolutely an unviable option, the association went full force in doing what they needed to do to come into compliance. And as you mentioned, it's a relatively small community, and without reserves, that's a very large number. Given conflicts with everything regarding labor shortage, supply chain, holidays, COVID, scheduling, everybody making improvements. I believe that the association did the best they could to come into compliance as soon as possible.
Well, and that's why I asked about material shortages, because frankly, none of us can say it because we don't know what it would have been, but had the association been moving faster, I think they probably would have suffered materials delays, because the landscaping materials were impossible to find.
And I don't
at
have any
that
evidence
end of the
saying-
year, beginning of the year.
Right. And I have no evidence saying whether or not
Yeah.
that was a material
No,
issue.
I know you don't, but I deal enough with clients who were suffering through that and not being able to get landscaping materials in that exact time of year. So I don't know that the delay that's concerning me, I don't know that circumstances would have been any different had it not been for the association waiting to actually have the money in the bank. Yes, sir?
I apologize.
No, you're fine.
Just as a proposal, I guess, in conferring with Officer House, I think the city would be more than satisfied at this stage, given all the factors involved, with a 10% recovery of the amount that's currently technically had as accrued, which would be, I think my math again, $1,180.
$1,100. I was thinking 1,000 was
Okay.
the number I had in my head.
I just used a percentage of, defer to your decision on that, and that would resolve, the costs have been paid, which obviously was appreciated that those have been resolved, so that would be acceptable to the city.
Well, I don't know. I have the president of the board here. They were a relatively new board. If you think that it may be helpful to understand where the board was coming from, he is willing to come up and,
I will listen to whatever you have to say. I don't know, I think I have my head around what was going on, so I don't know that it necessarily, I don't think it would help, or I don't know that it would help, I don't know that it would hurt, I don't think it would hurt. But unless something that I have said you disagree with and just trying to imagine what was going on, unless there's something that I've said that was wrong or something that I missed that I suspect was going on there, you don't have to. It's entirely up to you guys if you want to.
I'll just say one thing quick.
what?
Okay. Can I swear you in?
Yes.
Do you swear from the testimony you give us the truth, the whole truth, nothing but the truth?
Hi, my name is Christopher Todd. I'm actually the vice president of the Canopy Walk Board in St. Cloud. So I just wanted, you mentioned a statement about the reserve, and I think that's important. And I think it's important to add some weight to that. We are a small community, yes, that was mentioned by her, but the situation is that we're also a very young community. When we took over the board from D.R. Horton, which was a couple years ago, they didn't do proper things with the extending the budget for the second half of the community, so we started off with a special assessment. That's the first thing we had to do, was nearly double the HOA dues from all the homeowners. That being said, we didn't want to go immediately into another special assessment, but we had to. So we were trying really hard to figure out a way to be able to pay for all these things. So the reserve part was actually in our budget meeting, but knowing that we were going to have to do a special assessment, coming up with that, we weren't able to go forward with that reserve. And even if we did the reserve when we did the budget meeting, which is the last budget meeting, we wouldn't have gotten that money until the following year. So I just wanted to comment on the reserve part. We do want a reserve, but
When was the association turned over?
2000 and end of 2017, I believe, or 2018. I actually don't remember myself.
Close enough. I didn't need an exact date. I was just trying to get a sense of how far since developer turnover, how far removed from developer turnover you were. What would the impact of a $1,000 fine be on the association's finances?
I don't know off top. I'm not privy of the actual current budget that we have available.
I do not have a copy of your
Yeah,
finances.
I
It's
don't-
something that-
When is your annual meeting?
That's in October of this year. We'd have to double check that. It's a bit much different than $11,000. That's almost what we paid for the whole project to be completed.
No, and like you've already heard me say,
Yeah.
I'm not imposing that amount today.
And regarding finances, we are happy to look into that. I mean, as much as.
Well, it's the other thing that I'm struggling with up here is I do think, again, it's as much about fairness as anything. If it were an individual presenting to me, I couldn't do the work you ordered because I couldn't afford it yet. I didn't have the money in the bank.
I understand
I would
that
still
argument in the
impose
city's
something,
position.
although I do listen and try to understand what was going on, and I am persuaded by that. But I do have that $1,000 in my head. But what I also don't want to do is, obviously, as I just heard, the association not money problems, but there have been challenges as it's gotten its feet under it since
Correct.
turnover, and this situation and the lightning strike certainly haven't made that any easier for them. And I don't want to make those issues worse because I know that can fracture relationships between membership and boards, and when boards are constantly asking for special assessments. So I am incredibly sympathetic to the situation. Unless anybody has anything else they want me to hear, I am going to enter an order that will amend the prior order that will impose a $1,000 fine, but I'm going to give them until December to pay that. That gives them plenty of time to work it into their budget. It lets them get past that annual meeting, gives them an opportunity to figure out what those finances are and if they need to do anything with their budget. And I think you said November was the annual meeting, October, November. So that gives plenty of time. If you want to pay it all tomorrow, you're welcome to. If you want to wait until December, I'll give them that option.
And I will work with the association to make sure we can meet that deadline. You said December, not a specific date yet. I'm assuming that will be included in the order.
I was just getting it past the annual meeting, so
Understood.
December 1st, maybe we can do it before we get into the Christmas season.
Understood.
Anything else on this case?
Not from me.
Do you want me to send you a courtesy copy of that? I have your email address, I think, when I send that order.
Yes, please.
Okay,
I would appreciate it.
we'll do it.
Thank you very much.
Yes, ma'am. Thank you.
Have a good afternoon.
Thank you.
Case number 2017-1913, Frederick Driscoll III, owner, location of violation, 1323 Carolina Avenue, St. Cloud, Florida.
Jack Morganson for the city. This is a proposed request for reduction of fine lien settlement between Mr. Driscoll and the city. I met with Mr. Driscoll prior to the meeting, and just to explain, I'd be presenting this. The request is self-explanatory. I know his counsel is here and present, so if they'd like to be heard. But the city has agreed, the accumulated fine stemming from the case totaled $25,952.37. The parties agreed that in exchange or settlement of $3,002.37 to be paid within 30 days of your order, that the city would accept that as a full settlement of the matter, and of course.
So that's inclusive of costs?
That's inclusive of everything, yes, sir. And they're here if you'd like to hear from them or if they'd like to speak.
We put both cases on
What's the other case number?
I've got
Case number.
I have 2017-1913.
And 2011-426.
Yeah,
Yeah,
26.
I'm sorry, I should have said these are consolidated cases as contained in the settlement proposal.
Okay.
All right.
You've waited all this time?
Well, I've done a number of these. I've not been to St. Cloud before, but I was just up in Lecanto this morning. I hadn't been out there before. I got to see Christian Waugh. I don't know if you know him. He's an Orlando fellow, but handles the special magistrate for Citrus County. But explained to my client, he came into my office. He got a collection letter from DSK Law. Does collection, I assume, for the city. And met with them. I said, obviously the goal of most communities is to get compliance. It's not necessarily to be punitive, but they have to enforce these rules. If they don't, a lot of issues. And my understanding is there was already compliance, but this wasn't paid. We had this fairly large amount of money. So I contacted Attorney LeBoy and Attorney Manzares at DSK about if we could speak to the city about a suggestion of a reduction in the fine. Because he has been in compliance. There are older cases, obviously, 2011 and the primary one, 2017. But he's not a wealthy man, but can make these payments, and he's amenable to the agreement, if the city is agreeable to this, to be paid within 30 days after approval. I understand it has to be approved by the city commission too as well, but.
It's under 50. Yeah, so my approval is fine. If it's under $50,000, my approval is the
Yes,
last
sir.
approval
Well,
you
he's
have to get.
not a wealthy fellow, but he can come up with the funds to pay this, and he'd like
And
to have
30
it done.
days is enough time?
Yes, Your
I'm sorry, your name for the record.
Honor. I'm Attorney Joe Shoemaker with Bogan Munz and Munz on behalf of Mr. Driscoll here today.
Okay, well, the parties are in agreement. I think it's a reasonable resolution of the cases, so I have no reason to say no, and I will approve the reduction of fines, subject to being paid within 30 days.
Does he need to make arrangements with someone here to pay?
With, is that you or them?
Yeah, me.
I have her card.
You got her card?
Yes.
Claudia's?
I got Claudia's card. I think I've done some email with Claudia too as well. So can he come down after the meeting today to do that today?
Sure.
All right. Thank you, Your Honor.
Yes, sir.
Thank you, sir.
New business, none. Next scheduled meeting, May 18, 2022.
Anything further from the city?
No, sir.
One actually, with Canopy Walk having come, issue for everybody, I guess we wanted to have a little discussion because it was when you started with me after the last hearing. And when we have imposition of fines, I know we do the post-order right to hearing that they can request. But there's been, Canopy Walk was one where it got sent and I wasn't thinking about it, you weren't thinking about it, you guys weren't thinking about it, that, no, I had said I wanted to hear further on this case before I imposed fines. And then the one we were talking about last month was the 30 days. And you had said, do you want to hold them before you, it's 30 days after they're recorded that the appeal starts to run once we send the order. And, or I guess, once we send the order, so I still have to sign off on the order, which you then send, so you have to sit on them for 30 days. And I think we covered that, but it's not that, we can't wait 30 days to enter the order imposing fines, because it's the order that triggers the 30-day appeal right. So I was trying to think of how to resolve those issues of making sure that we're not imposing fines early. And the one option I know is not a preferred one, and so I haven't given much thought to that one, which was, well, we can do pre-imposition for everything. That requires you to have more hearings, and probably not necessary, since a lot of them, they choose to waive their right to appeal. So I kind of wanted to have a discussion with all parties involved on a way that the affidavits of noncompliance can be given to Claudia and then given to me as they already are, but just notating where we are in cycle on cases, because I get I get the batch of those. Most of them are the recent ones. Some of them are older ones, but just making sure that we are all on the same page in what you're asking me to do, and then am I doing what? Am I thinking of it in the same way? Am I thinking of it in the same way that you're sending it to me? And just making sure that we are allowing everybody their right to be heard on matters where they have a need to be heard. You following me, Jack?
I am. I'm just, what I'm trying to do is sort of come up with some contribution to addressing the issue, without causing more complications. So conceptually, we have a hearing. There's a violation of time for compliance is presented in the order. If a failure to comply, in some instances, you want to have it reviewed before any imposition of fine is.
And that was easy enough to do.
And that's fine. And then we make note of those, or we should be making note of those, to bring those back, as we did today with the motion to impose. For matters that don't need that consideration, the affidavit of compliance in the cycle comes back to Claudia from the code enforcement officer.
Always add a note in the email when we send you the non-compliance affidavit back, stating where we're at with that case.
And that's kind of what I was thinking of. One way of dealing with it was not just a note on a file, but even if possible, and if it's possible without creating more work, because it's not, I don't have the power to tell you what to do.
Yeah.
But it's just a thought.
What makes it,
is if we have a spreadsheet that tracks all open cases, that you and Claudia are sharing, so that you see, okay, we've sent over the order imposing fines, the spreadsheet is updated, Claudia sees that. It also will help Claudia and I on our end, because sometimes, I will miss an order, or I think I've sent it and I haven't sent it, and she'll poke me and say, have you done this order yet? And I think having that spreadsheet between code enforcement and clerk would actually help everybody be on the same page. And then, if there are those cases, when there are those cases where I say, I want to hear this again before I impose fines, we can put that in the spreadsheet.
Note that as such,
and
sure.
then we can all just be double checking against that spreadsheet. And then at the end of it, at the end of the boxes, you have when was the order signed, date the order was signed and recorded, and then when that 30-day clock is run to record date. You can even put a box for record date in the spreadsheet. But again, I can't create work for people, but that is a.
And we don't typically have a lot of these situations, but I think when Canopy Walk was done, we were also doing the Benjamin Estates, and I believe that's where you stated we would bring it back before any fines. And I don't know if she just got that confused. I don't know. But nobody reached out to me through that whole process. And when she called me and said, hey, we're done, I went out that day, took photos, did the inspection and everything else.
Well,
and that's
what,
she didn't realize.
understood. But I think Officer Sparkman confirms that the spreadsheet is a workable tool to use with Ms. Clockers and for you. And we'll do that.
Okay. Okay, great. That was all I had.
As long as Officer Neal agrees.
This isn't being.
Okay, I just want to make sure that we include Pam. She hasn't been quiet.
Part of the minutes, doesn't have to be recorded.
Okay.
I haven't adjourned it.
Okay, sorry, I didn't hear that.
Okay, all set? All right, then we are adjourned.
Okay, so attorneys don't have to be sworn in?
Attorney
Oh, okay, that's where I got confused.
Well, so she was, because of what we were